Hi, this is attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Today I'm going to talk about an important difference between DUI convictions and wet reckless convictions. Now, you may know from your own research or for watching our previous videos that when defending a DUI case, there may be a conversation about whether you might end up going down on a DUI charge or a wet reckless charge, or ideally no charges, if you can get a dismissal or an acquittal. But assuming you end up getting found guilty of something, it's often spoken about whether or not you can instead get convicted of a wet reckless charge anyway. Wet reckless is governed under California Vehicle Code Section 23103 and 23103.5. This allows someone facing a DUI charge to be found guilty of a type of reckless driving offense instead. There's many differences between the two offenses, many similarities as well. I'm going to talk about one important difference here, and that is how to deal with the DMV after you've been found guilty of a wet reckless offense instead of a DUI. If you're found guilty of a DUI offense, that mere fact of a conviction gets transmitted to the DMV, and based on that conviction, the DMV will suspend your driving privileges. If your driving privileges are already suspended, or if you never had a license to begin with, well, they'll just either, in the former case, probably issue a different suspension that's consecutive to the suspension you're already serving. Or alternatively, if you never had a license to begin with, they would simply suspend your license by prohibiting you from getting it for a relevant period of time. In the event that you're convicted of a wet reckless conviction, you are not necessarily going to be suspended. And the difference is most important in the case of first-time offenders. Again, if you're an alleged first-time offender and you get found guilty of DUI, that fact on its own triggers a suspension. The DMV will suspend your license for a period of time based on that, and they will suspend your license in most cases for a period of 6 months. And it will start from the date your conviction in court becomes final. What that means is when you're convicted of DUI, no ifs, ands, or buts, you're getting a license suspension starting on that court date when your conviction becomes final. When you get convicted of a wet reckless, that doesn't necessarily happen. When you're convicted of a wet reckless, a suspension does not necessarily start on the time of your court date. The DMV will pretty much say, well, okay, you've been convicted of wet reckless, but we may still decide to suspend you or we may not. And in that scenario, you and your lawyer may decide that it's still worth it to fight the DMV hearing and see if there's a way to get the DMV to stop you from being suspended. Again, if you're under 21, that type of conversation might not happen. Because if you're under 21, there's what's called the zero tolerance law. So a wet reckless in those scenarios will still trigger a 1-year suspension like a DUI. But if you're over 21 and you're convicted of a wet reckless, you and your lawyer should do a lot of strategic planning about, one, whether it's still worth it to fight the DMV hearing, or two, to instead concede the DMV hearing, but concede the DMV hearing at a certain time so that you know when the suspension is actually occurring, and then you can make arrangements for restricted licenses. And that's another issue that comes up because if you want to get a restricted license, you may have to sign up for more DUI school than the court requires you after a wet reckless conviction. If you're convicted of a wet reckless, the court may only require you to do a 12-hour DUI school. But if you end up getting a license suspension anyway for the same instance, and you want to get a restricted license during that period, the law requires you to sign up for at least a 3-month DUI school. Now, obviously, a 3-month DUI school would satisfy any court order requiring you to do a 12-hour school, but you still have to make the choice. And in some situations, the court you're in is waiting to see proof of DUI school enrollment by a certain time. And if you wait too long to make a decision on what you're going to do with your driving privileges, you might end up irritating the court and then opening up a probation violation. But with proper representation, proper advice, and some real thought and planning, you can avoid all those pitfalls. At the end of the day, it's actually really positive. When you're convicted of wet reckless, you have choices, you have options. Do you continue to fight the DMV hearing? If you do, what are your arguments going to be? Are you able to show that the DMV cannot prove that you were 0.08 or more at the time of driving, that you were even driving at all at the time that you were impaired or had alcohol in your system? You can still raise those arguments following a wet reckless conviction. Alternatively, if you don't think you have a good shot at that and you just want to control the suspension period, because remember, the DMV can still suspend you if it is convinced that you were in fact driving with a 0.08 or above. If you don't think you're going to win that argument, maybe you want to tell your lawyer, hey, just cancel my DMV hearing at date X, and then I know when my 4-month suspension period is going on, and then I can make arrangements for restricted licenses if I'm interested. It's fascinating that, the wet reckless is an often sought after disposition for certain type of DUI cases. It's considered a lesser offense, and yet it unlocks this sort of Pandora's box of complicated decisions that one has to make, which can be particularly overwhelming if your DUI case is the first and hopefully only time you have an interaction with the criminal justice system. But again, take a deep breath, think about it, get good representation, and you'll be able to navigate these complicated issues with ease. I hope this was helpful for you. For any more similar videos, feel free to check our YouTube channel, our Instagram page, and our law firm website. Thanks, and stay safe out there.